A New York State judge will soon decide whether some potentially embarrassing emails written by the former president's eldest son, Don Jr., should be made public. According to the Wall Street Journal, these emails written years ago include offensive and disparaging comments about Jews and Mexicans. It's all related to a current legal battle that involves a Texas financier named Gentry Beach, a close friend of Don Jr.'s who served as a groomsman at his wedding. Beach has been fighting a seemingly never-ending legal battle against his former employer, Turigi Capital Management, claiming the hedge fund owes him tens of millions of dollars. The emails, which allegedly went back and forth between Beach and Don Jr. between 2005 and 2008, were sent from, at least from Beach's end, his work email account. And the firm maintains that the emails are relevant to the case because they support the company's claim that Beach was fired for cause, that he and a co-defendant were dishonest and unskilled employees, disloyal to the company, and exposed it to reputational harm. The argument is that it is definitely not a good look if your company is handling millions of dollars for investors and the people in charge of making decisions for them are sending company time, they're receiving racist emails. The Journal reporting on one email thread that included a message from Donald Trump Jr. that blamed another member of the message group for Mexicans coming to the U.S., encouraged the Mexicans to come to the U.S. and give them another excuse to not learn English. When I have to speak to my grandchildren in Spanish, at least I know I'll have you to thank. In another email, Don Jr. reportedly replied to the news of Beach's family moving to Harlem, which is predominantly black, with the "I Hear the Theme Song of the Jeffersons" playing in the background. Beach's lawyers questioned the motives for opposing counsel for wanting the emails, saying the only legitimate purpose for peppering the record with references to the public figure's name is to prejudice the jury pool for the retrial and to increase risk of reputational harm to plaintiffs, perhaps to generate settlement leverage. Beach is seeking to have Don Jr.'s name redacted in case documents, probably out of loyalty to his friend, but not so much loyalty that he's willing to drop a case where at one point he was awarded $91 million. There's now been a retrial. Earlier today, State Supreme Court Justice Andrea Masley said Beach's embarrassment was not enough to remove Don Jr.'s name, but an official decision on whether to admit the emails has not been announced. Joining us now is Rich Schoenstein, a New York-based civil litigator who's worked with high-profile clients on confidentiality issues. He's been following this case closely. Thanks very much for coming on the show. Appreciate it.
My pleasure.
So it sounds like there are probably some other emails out there that even the Wall Street Journal didn't report on.
You would think so, because they're still fighting about this issue in the court. And if we've already seen everything, why would they keep fighting?
You know, the thing that it seems odd to me is that, at least based on the stuff we saw, this is consistent with stuff Don Jr. has said publicly.
Right.
I mean, I don't think, if there's nothing more, I don't know that Don Jr. would care about those particular emails coming out, right?
Yeah, he might not. It's not a surprise to anybody. We might expect a lot of emails like this, and that could affect the judge's decision here.
Right. Look, I think there's got to be more. There's got to be more emails. We'll see if there are. But let me ask you now, on the legal side, do you expect that the judge will allow for the release of those emails? It does sound like a bit of a long shot argument that they're making as to why they need Donald Trump Jr.'s side of the emails here.
So I think she'll let the emails in the record because they were used at trial, but she may allow the names to be redacted because that's consistent with the prior order in the case. And it does seem gratuitous. Donald Trump Jr. doesn't have anything to do with this case. He's not there substantively. So she might allow the redaction of his name. But if the emails are in the record, does it matter anymore?
We'll still know who the person is.
And any redacted email we see in that case now, whether it's from him or not, we're now going to assume was.
Right, but this is a new theory, right, that the firm is using to say, oh, we want to try and add these emails to our defense. This is not something that they've argued in the previous trials?
At least some of these emails showed up in the last retrial of the case. One of the defendants' argument is that the plaintiff used these emails in their case and therefore waived the confidentiality. That's something the judge will consider. But I agree with you. There's probably more emails that we don't know about.
All right, we shall see. Rich Schoenstein, thank you. Appreciate it.
Pleasure.
Thank you for watching. Go to NewsNationNow.com to find NewsNation on your cable provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.